Good evening, everyone. Thank you for joining us this hour on The World Tonight. I'm Kelly Wright.
I'm Nayyera. Today, the highest court in the nation heard arguments on Texas's abortion law. It's the strictest in the United States, which bans abortion at 6 weeks, before most women even know they're pregnant. There are no exceptions for cases involving rape or incest, and it gives citizens the ability to sue each other for exercising their constitutional rights under Roe v. Wade. Students for Life of America rallied in support of the law outside the Supreme Court today on Capitol Hill, along with other pro-life groups chanted, sang, and prayed. Pro-choice demonstrators were also there. Some held signs and wore shirts saying, quote, "Abortion is essential and bans off our bodies." The court itself is a very conservative one, with only 3 justices leaning liberal. Although conservative, Justice Amy Coney Barrett raised questions about the law's structure and how it would be difficult to defend. Liberal-leaning Justice Elena Kagan called the law a chink in the armor of federal law.
And the fact that after, these many years, some geniuses came up with a way to evade the commands of that decision, as well as the command that the even broader principle that states are not to nullify federal constitutional rights. And to say, we've never seen this before, so we can't do anything about it. I guess I just don't understand the argument.
BNC correspondent Derek Lewis joins us live now from Houston, where he spoke with one of the plaintiffs about what's at stake in a case SCOTUS is hearing today. Derek.
Yeah, Kelly, Whole Woman's Health is an abortion clinic here in Texas, and the lead plaintiff in this case, Marva Sadler, a director at the company, says today's outcome could be what she wants. However, the damage has already been done. Throughout the day, Marva Sadler has been relying on her attorneys to handle what's happening at the Supreme Court.
We're super excited and hopeful that the Supreme Court will make the right decision to move this forward.
With so much uncertainty, she knows a ruling may not be in her favor.
We're also very cautious in knowing that today will not be the end all of it all, and knowing that the direct relief will not come today, which is ultimately what we're waiting on.
She's hoping for an end to SB 8, the Texas abortion law that went into effect September 1st. Whole Woman's Health has 4 clinics in Texas, and for 2 months has seen the number of patients drop more than 50%. Some don't even bother to call now.
The initial choice of abortion now seeming to be unobtainable. So even our incoming calls of patients just calling for information have begun to decrease.
She fears the damage that's already been done will be long-lasting for women of color.
Those women who have not been able to make it out of the state of Texas, who are now going to have babies from unwanted pregnancies in the next 8 to 9 months, and what that's going to look like for our communities. It's something that we can't avoid at this time. It's going to happen.
The Supreme Court will decide whether to move forward with the case and if the federal courts have the power to block Texas's abortion law.
A lot of us, what happens today will kind of weigh in on whether or not we can take a breath as we move forward and get ready for what's next, or if we really need to continue to be on guard. But in reality, until SB 8 is no more, the tension stands no matter what.
Now, those who represent Whole Woman's Health here tell me that this ban is the most restrictive in the country and that it undermines the fundamental foundation of the constitutional democracy. Live in Houston, I'm Derek Lewis for BNC.
All right, Derek, thank you for that. Joining us now is David Donati. He's an attorney with Texas ACLU. And David, when you look at what's happening in this case and the fact that the Supreme Court is now questioning aspects of this case, what comes to mind for you right now in terms of what the women of Texas will be able to possibly accomplish dependent on how this case turns out in the Supreme Court as well as in Texas?
I think it's the right place to start, to understand that this law has been in effect for 2 months now, that we've been fighting this case since July. And it's been so important to us to try and prevent this ban ever from going into place, because As soon as September 1st, when the ban took effect, we knew it would have devastating effect for Texans. And I think that we've seen that play out in every way that we expected it to do so, and in ways that we didn't expect it to do so. And so I think Ms. Sadler absolutely hit the nail on the head when she was talking about the effects on Texas women. Many of them have been able to leave the state, especially thanks to an influx of resources, charitable donations to abortion funds that are helping people in difficult situations who now have to leave the state. But just as many women are not able to actually access abortion care at all. The 6-week ban takes effect before most people know that they're pregnant, before the majority of abortions in the state of Texas are even taking place. And so many people are just not able to access that care here. And many people, particularly people of color who don't have economic resources to leave the state, who may not have care, who may not have the ability to leave their job, they are being forced either to decide before they're ready to decide to terminate a pregnancy or to carry a pregnancy to term. And so we've seen it, we've seen the effect in clinics in other states who are now taking an influx of Texas patients. And I fear that it's going to get worse as time goes on, as resources dry up, as attention dries up to the issue as well.
One of the justices that raised concern during her confirmation hearing was Amy Coney Barrett because she refused in her hearings to affirm Supreme Court precedent Roe v. Wade. What did you make of her line of questioning today?
I thought Justice Barrett asked some wonderful questions, and I think for us as lawyers who are fighting these fights, we tend to look at things as objectively as we can, not Republican or Democratic issues. And I think Justice Barrett was really rightfully uncomfortable with the structure of SB 8, because however one may feel about the right to an abortion, and I think all of us here who are fighting this case feel very strongly that the right to abortion is a fundamental one that goes to fundamental human dignity, the decisions we make with our bodies, our right to privacy. But even someone like Justice Coney Barrett, who may not have that same ideological viewpoint, nonetheless is rightly troubled by a state like Texas saying, we don't like that fundamental right, we're going to figure out a way to get around it. We're going to design a law that allows anybody anywhere to sue in any court in Texas's 254 counties, and there's really no way to defend even in the state court system. And Justice Barrett, I think surprisingly for a lot of us, but really in a way that was persuasive and powerful, highlighted some of the structural problems with the law that mean that this court, even a conservative court, should strike it down.
And David, let's go back to the Texas law, because within the law, it doesn't go after the women who choose to have the abortions. It goes after people in terms of turning in those who actually escorted the woman to the abortion clinic, and then it sues the abortion clinics for performing these procedures. I wanted to ask you, is that really what has caused the Supreme Court concern, because it gives the atmosphere of creating bounty hunters?
I think that there is a lot behind Texas's choice to structure the law in the way that it has done. It very much, I think that the architects of this law have treated it as a game. They've looked at all of the court's decisions about abortion, about access to judicial review of federal constitutional rights, not just in the abortion space, but in the desegregation space, in the political primary space, in the education space, and they have tried to structure a law in a way that makes it nearly impossible for a federal court or even a state court to review the constitutional questions at stake. And so they deliberately excluded women who are receiving abortion care from being sued under this law, with the goal of making it harder and harder for providers, for people who are supporting those women, from vindicating the constitutional right to an abortion. Because from where we sit, it's actually quite meaningless that the women who are receiving abortion care are exempted from it, because the law makes them islands. You can't just receive an abortion by yourself. You have to go to a doctor, you have to pay for it in some way. And when you go to a doctor, it requires clinic staff, it requires radiologists, people taking an x-ray or an ultrasound. There are so many people involved in this. And I don't hear Texas to be suggesting that women should take the abortion procedure into their own hands. What they're trying to do is instead eliminate any access to care that a woman might have and make it impossible to access the federal judiciary.
But David, that's not unique necessarily, right? The idea that providers have been restricted in what they can do is part of the architecture nationwide for the pro-life movement to challenge the right to choose. But there's something that one of the justices raised today that seemed like it made SB 8 particularly problematic in the eyes of the Supreme Court, that the logic of SB 8 could be the same logic used to attack gun rights.
That's absolutely right. And that's why I think that we saw justices like Justice Coney Barrett and Justice Kavanaugh, who we would call conservative, come out and express discomfort with this law. And John Roberts, likewise, we would call him a conservative justice, but he's expressed discomfort with SB 8 from the beginning. And I think it's because it's so plain to see that our federal constitutional rights shouldn't be subject to gamesmanship in this way. At the point where everyone agrees that there is a fundamental right that's being systematically violated, there should be no impediment to going to a court to redress that violation of federal rights. And guns rights groups have submitted briefs in our case to argue exactly what you've identified, what the justices identified, that abortion may be first on the chopping block, but any fundamental right, any right whatsoever, is susceptible to the same abuses that Texas has perpetrated here. So guns are an easy example, but likewise, the practice of religion, the free practice of religion that this court has stood behind, is something that could easily be delegated to your neighbors to sue whenever you criticize the government or you practice your faith in a particular way. And so it cannot be that just the fact that anybody anywhere except the state can get you in trouble for a particular type of conduct insulates that conduct from judicial review.
Right, the idea that just because you don't like it doesn't mean that you can take the law into your own hands. David Donati, thank you so much. David is an attorney with the Texas ACLU. We appreciate you joining us tonight.